So the Congress of the People are working with Dignity SA yet again, and they're bringing to the fore the issue of euthanasia and the rights of a patient that lack capacity to consent to medical treatment debate to the fore. We're going to continue this conversation now. My two guests in studio, we've got Deirdre Carter, she's from COPE, she's the Parliamentary Chief Whip, and Dr. Josie Letlape, who's the President of the HPCSA. So Deirdre, before the break, I said I would come to you, and let's just keep this conversation going and on a very understandable level. It's not a matter of, and the doc and I were talking, we brought a very real case again. Let's take that of Golani Gwala, for instance, because he was diagnosed with stage 4 cancer, but he still had the right to decide whether he wanted treatment or not. That's not where this kicks in. This would kick in, I imagine, just as you have written a will where you say, when I die, I would like to leave X, Y, and Z too. So this will would kick in, or your desire would kick in once you cannot make a decision for yourself. You are unconscious and you're in a state where, you know, it's up to the medical professionals and your family. So this would be filed with a lawyer or whatever it may be, whatever the case may be.
Absolutely, you are right there. You know, I was just saying as well, I'm diagnosed with cancer. I have a right to decide whether I want chemo or radiation. And I can refuse that right. I can say that I don't want chemo and I don't want radiation when I'm able to talk. But when I'm no longer able to talk or to make any decisions, that is when you want your will to kick in.
Yeah. When would you like it to kick in? Just at that point where you physically as an individual cannot make this right. Not that you're lying in a hospital bed and you're still fully aware, but you're aware of the fact that you are not going to make it. No matter what treatment you get, can you make the decision then?
Yeah. You know what, we've looked at, there's a form that we're looking at, okay, but we want to meet with the Department of Health as well to, you know, we want this to be joint. We don't want this to be a political football. We really want this to work. And so with this form specifically, it's maybe a little bit too advanced to say now to discuss it, but I'm going to give you an example. You've got a sudden onset of a life-threatening illness of irreversible nature, for example, a brain injury. Okay, or you have had a massive stroke with no chance of real recovery. You can then say that just keep me comfortable and pain-free and no additional treatment, no ventilators, etc., to keep me on. So this is when it would kick in. Say, for example, you've got organ failure or incurable cancer. So, you know, you would specify in that form different scenarios or medical scenarios. You don't want to be hooked onto artificial breathing support, for example, a ventilator. You don't want to be mechanically or artificially have your heart stimulated. You know, those type of things. I don't want to be in a position where I'm in a coma and I'm being force-fed. Yeah. So that is when that would kick in. So you would definitely go. And something else is what we're looking at is in the process, with it being a legal document, we also want to almost like you would have in a credit period when you take out new credit, that you've almost got like I don't want to say a cooling period, but there would be 3 different signing periods. So you would do this, you would sign period number 1 with your witnesses, you will have a second signing and a third signing. And I must say that the shelf life is something that we're also looking at.
Okay. Just give us a bit of the law here. The SA Law Reform Commission recommended back in 1999 that advanced healthcare directives such as living wills be legalized. What's happened to that recommendation?
Well, that recommendation has really been lying in Parliament gathering dust. Late President Nelson Mandela actually requested, it was originally specifically on living wills, and he then requested that it should be expanded to another 3 legs, which also included active euthanasia. So the Law Commission actually, they even drafted a draft bill. But unfortunately, the reasons I cannot explain to you, but it's gathered dust in the archives of Parliament, and we are now in the process process of trying to revive, especially the 100th year celebration of Madiba's life, to revive at least one leg, which is for living will.
So, Deirdre,
we've also seen the support of Archbishop Desmond Tutu on the matter.
Okay, if you can, just as succinctly as you can, what does the law actually say about assisted and dignified dying? I mean, you can call it assisted suicide as well, but that I think is a little bit of a harsh way of putting it. But if you can, what does it stipulate currently?
Well, you know, assisted dying is not allowed, all right? But what you can do in terms of Section 6 and Section 7 of the Act, you can refuse treatment. Okay. And that is within your right. A full bench on the 6th of December 2016 in the Supreme Court of Appeals found that if a patient is given treatment that they don't want, it is actually, it's assault. It's assault to a person.
Mm. I think, Dr. Letlape?
I think it's important that those distinctions be made. That when you're still conscious and you can make your own decisions, you can refuse treatment. And there is no healthcare practitioner that can give you treatment against your will.
Yeah.
It would be against the ethical principles. But I'd also like to make a comment that we need to be careful when we craft these documents about living wills. And it should not just be about a legal document. I would suggest that a palliative care specialist be involved.
Okay.
Because people need to know what they're signing for. Because you need to describe it quite carefully. Because if you are in an accident, you'd want to be given a chance to live, you know. But we know that sometimes if an accident is horrific, people might think you're not going to make it, and with treatment you make it. So we've got to be quite specific about the circumstances, where people would need to specify, if I have a terminal illness, which would require a medical opinion on that matter. If I have a massive heart attack with prospects of recovery not being good. So we need specificity in that living will so that it is clear and not ambiguous to practitioners as to what your wishes are, so that we are not stopped from giving life-saving treatment where people can have full, fruitful lives after medical interventions.
Okay. Let's wrap it up. We just a few seconds before 8 o'clock on the program. Deirdre, when are you expecting the parliamentary process to actually begin on this?
Okay, well, it is now open for comment, and comments can be sent to the Speaker of Parliament and copy me in on them. And those must be in by the 22nd of August. Also, like I said, I've written to the Minister, and I'm hoping to meet with the Minister and the Department before then, also to get, you know, their input so that we can work on this together.
Right. Let's leave it there for this morning.
I think, lastly, people must understand, we're not talking about euthanasia, either passive or active. That is still unlawful. That is a criminal act that is prohibited in terms of the ethical codes of conduct of the Health Professions Council of South Africa. So in this country, euthanasia in any form is unlawful. As healthcare practitioners, as doctors in particular, we're not in the business of killing our patients.
Indeed. This is the right of the patient and abiding by the wants and the will of the patient.
Yes, we can withhold treatment. Okay. We don't have to prolong life unnecessarily, and we have a proper palliative care procedures that need to be followed, and we have good palliative care specialists that will ensure that patients are taken care of, but their rights are not violated, and you do not prolong life unnecessarily.
Dr. Khosi Letlape, the president of the HPCSA. 1 second. Sorry, Deirdre, we have entered into the 8 o'clock hour, so I'm going to have to wrap this up here and go to the news. But I think we've got the point across quite well. Deirdre, of course, is Deirdre Carter. She's the Parliamentary Chief Whip of COPE. Apologies. Thank you so much for joining us here on the program. All right.